Good morning. That was the sound of a gavel. We haven't heard that in a while. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, June 9th. Time is 9:30 a.m. With us this morning are Commissioners Emily Lindley and Bobby Janecka and our General Counsel, Mary Smith. I'm John Neerman, and we are back at the dais for the first time since March of last year. The pandemic is not over, but it's waning, thankfully. And so we're taking this step today to be back in the agenda room as we move towards whatever the new normal is going to be. I do want to acknowledge that the pandemic has taken a horrible toll, claiming the lives of 50,000 of our fellow Texans, more than 50,000. Currently, just over a third of our fellow Texans are fully vaccinated. Cases in Austin are, and this is a 7-day average, at about 30 to 40 new cases daily. Hospitalizations are at about 70 to 80, and there are about 14 people on ventilators in the Austin area. So those are the local conditions, and the point is that this pandemic is on its way out, clearly, but there is still some risk in the community, and that risk looks a little different to each of us. So I'd like to ask you to be mindful of that as you make personal decisions about the appropriate way to protect your families, your loved ones, your neighbors, and yourself. And please be kind and understanding of each other and respect the personal decisions of the people around you. This is a hybrid meeting in that most participants are with us virtually, and it's our first meeting of this kind, so please be patient with us if we encounter any technical issues. I'd like to remind folks to keep their phones on mute when they're not speaking. I'd also like to remind anyone who's here only to listen that they can watch the meeting online, and that link is available on the agenda notice. For each item where argument or discussion is allowed, we'll inform speakers of their time limits. Registration has now closed, but if you would like to address the Commission on a particular item, please email agenda@tceq.texas.gov with your name, your affiliation, and the item you'd like to speak on, and we'll try to accommodate that request. For those who are making presentations, please wait to begin your presentation until either I or our General Counsel have asked you to begin speaking, and please check to make sure that your line is unmuted before you speak. So admonitions are out of the way. Colleagues, I want to give you an opportunity to offer any comments if you'd like. Commissioner Lindley?
Good morning in person. I don't have any comments. I appreciate everything you said, and I'm happy to be up here and see you all. Even though we're not fully there yet, this is a step in the right direction. It's exciting.
Good to be together. Mm-hmm. Commissioner Janecka?
Nothing more than an enthusiastic ditto. Thank you so much for making those remarks, Chairman. I think that that's a great reminder for all of us, and a particularly helpful context as we step into a different but ever-changing posture as we try to serve the public.
Thank you, Commissioner. All right, with that, I'd like to thank everyone for being present, the few of us in this room and many of you virtually. And Ms. Smith, I'll ask you to please call the first item.
Old business item 1 is the consideration of the ALJ's proposal for decision and proposed order concerning the application of Bosky Solutions, LLC for air quality standard permit for a concrete batch plant number 152013. The Commission will not take further oral argument from the parties, but may ask questions. Those who have signed in will be noted for the record. Representatives Tinderholt and Cook have requested to address the Commission on this application, and as a courtesy, the Commission customarily allows statewide elected officials and members of Congress and the Texas Legislature to address the Commission on items. However, the Commission may not consider those comments in its deliberations pursuant to Texas Government Code 2001.041, which requires the Commission to limit its consideration of any application to the evidence and matters that are officially noticed.
Representative Tinderholt, are you with us? Can you hear us? And we're not hearing you. Let's try it again. Can you hear us?
Can you hear me now?
We can. It seems to be working.
Perfect. I had muted myself and I didn't realize it, so I apologize.
That's all right. Good morning. Yeah, you're coming in loud and clear. It's good to hear you and hear from you. So, Representative, the floor is yours.
I appreciate you letting me speak today, and I'm happy to see things starting to go headed back toward normal. Your statements earlier were appreciated, and I think most of America is ready to start getting back to some sort of normalcy. So I'm glad to see you guys are doing the same.
Yes, sir.
I'm here speaking today because this community butts up to my district. And, I made some notes, and I'm going to bounce around a little bit. I'm going to try to stay kind of succinct to be respectful of time. But as I talk to these folks, essentially, you've heard from them. You've heard from attorneys. I know that they're just neighbors. They're citizens that are trying to protect themselves, their health, and their families. And I think TCEQ wants to do the same. I know that that's what TCEQ, essentially what TCEQ, part of what they exist, is to do that, is to protect the citizens of Texas. I think that TCEQ has valid reason to deny the permit. You guys sent it to a SOA judge. SOA judge came back and was specific and said, look, I think it should be denied. Fort Worth has the right, according to, I believe, your own rules, to be notified via the paperwork. If rules and paperwork and laws, if they matter, then I think it's easy to deny this. I think that even if you take the EPA requirements of silica out of it, I think it's still an easy denial according to what y'all's mission is. I thought about it after we talked the other day, and I decided to go back and I watched several of the previous meetings. And as I watch these meetings, what concerns me is I want to quote one person that said they want to find a pathway to get Sheffield his license. That is concerning to me. That is very, very concerning to me because we all know what the mission of TCQ is. We know that protecting the citizens of Texas is very important. And I'm being generic when I say protecting the citizens. Your mission and vision statements are a little different, but essentially that's what you exist for, is protecting citizens of Texas. And so one individual getting their license should not overwhelm and overrule the SOA judge and the paperwork that was not checked off. I feel that TCEQ should be protecting the citizens, but it appears, and I want to use the term perception because perception is truth to the person that perceives. It may not be the truth, but it appears to me as I watch these videos, the perception is that TCEQ is potentially trying so hard to get this permit, and they're trying to protect him and TCEQ themselves, that this license, this permit is potentially going to get processed. And I think that that potentially, my perception is that TCEQ should focus more on the rules and policies and procedures. As I watched the meetings back, I had serious concerns about transparency. The meeting that I spoke at on May 19th, y'all took a break and y'all went back and you talked to attorneys, but you didn't go into executive session, and open meetings matter and transparency matters. And when y'all came back, you seemed to have some sort of resolution and idea of how you wanted to move forward to try to get this license and this permit process. When in actuality, the citizens and state reps like me, when we go back and watch these, I see an absolute, probably not purposeful, by the way, but an absolute lack of transparency. When you go back into a back room and you meet with attorneys and you all come out with a plan, it appears that transparency, actually, it lacked transparency. And so I'm imploring you. I'm telling you, it appears to be an easy decision. It begs the question, why are we even talking today? Why is Representative Cook having to get on the call? Why are all the people having to listen? This keeps coming up. You have your own rules. You have a SOA judge ruling. You have the paperwork that was required to have a checkbox noted on it. And I said later, let's not even talk about the EPA requirements. Let's not even talk about the silica. Let's just talk about those two things and the mission of what TCEQ exists for. I would implore you to seriously consider denying this permit today. And I want to reiterate, I don't think that a lack of transparency would be purposeful in any way whatsoever, because I listened to a ton of these meetings. But it is concerning to me. It is very concerning to me that I heard things similar to my quote about getting Sheffield his license. Well, that's not what this should be about. This should be about protecting the citizens of Texas and doing what TCEQ needs to do according to their own rules, state law, policies, procedures. I just feel like this is really a simple decision, and I want to thank you guys so much for allowing me to speak. I'm not trying to poke anyone in the eye. I just want these people to be protected. I want them to have their voices heard, and I want rules and policies and laws to matter. If this individual wants to file a new permit, if it's denied, they can go do that. But this one's not valid. So a judge said so. Kicking the can down the road is the wrong answer today. I think a vote of no is the right answer today. And I thank you guys so much for what you do, and I thank you for allowing me to speak today. And I apologize if I seem harsh, but this is really important to the citizens and their health in that community. So thank you very much. I appreciate you guys today.
Thank you, Representative Tenderholt. We do really appreciate you being with us this morning, sharing your comments and perspectives. I really do appreciate that. We good? Okay. Representative Cook, are you on the line?
Yes, sir.
Good morning, sir. Go ahead when you're ready.
Well, thank you, and I'm so thankful for Megan and your team and making sure we're in the right place at the right time. And so glad I did not waste more of your time like I did last time. So, but I won't take long. Really, what I have to say really is in succinct with what Representative Tenderholt has already said. And I think there's a lot of times when we give presentations, we talk about 3 points. We have 3 points to make, and so I mean, obviously Representative Tenderholt, has already talked about 2 of the points that stood out to me as well. And one of those was getting Sheffield his permit. Number 2 is potentially an open meeting violation. I was a mayor for 12 plus years, and anytime we went back into a closed session, we always informed the public not only that we were doing it, number 1, but number 2, also the specific point of law that we were recessing under. And like Representative Tenderholt, I did not see that occur last time. And I got the same impression that Representative Tenderholt did, is that a plan was developed, and which leads me to point number 3, which is the one that just is unfathomable to me, that this commission would consider changing its rules in order to get Sheffield his permit. It's just, if that happens, I just can't tell you what lengths that I will go to in order to change this process, because it is ridiculous if you go back doors, like the transparency, come up with a plan, and you literally on May 28 put out TCEQ opens comment period for air quality standard permit for concrete batch plants. That is amazing to me that we want, as a state, to get this permit to this person so bad that we're willing to change the rules on these people that have spent thousands of dollars out of their personal pockets just for the betterment of their everyday lives. And so, as Representative Tenderholt says, I implore you to do the right thing. If Mr. Sheffield wants to go back and he wants to file a new application, then he has the right to do that. But this commission has a responsibility to interpret this application based upon the rules that were in place when this application was submitted by Mr. Sheffield. If he did it wrong, that's his fault. These people have followed the law. They've paid attorneys to do it. They've done so much more than what most of the people do that come before this agency. And I would just expect that y'all will do the right thing and interpret this application based upon the law that these people started spending their money on with an attorney, and make Mr. Sheffield play by the rules that have been in place this whole time. Don't rely on this new comment period that TCEQ, and I understand mistakes happen. I make mistakes every day. No one's perfect, and I get that. And no one sitting on this dais is responsible for the error that occurred in 2012, as what I understand is the issue. And if that's the case, so be it. Let that change affect future applications. Do not make it retroactive. Last time, and I'll shut up and move on and let you know you've got a long list of items on your agenda today. The last time I talked about a no evidence motion for summary judgment, and I know that, just bringing legal terms. The legal term that I bring in today is a subsequent remedial measure. That's what, in my opinion, when I see the commission trying to change the law, change the rules in the middle of this application, the consideration of this application, after a SOA judge has already made a decision, this commission should simply affirm what Judge Summerhays has already done. But this, to me, under Texas Rules of Evidence, there's something called subsequent remedial measures, and it just means that someone can't be penalized for trying to do something that correcting a wrong. And that's what appears to me that y'all are trying to correct a wrong, and I commend you for doing that. But I think the commencement of correcting the wrong needs to apply to future cases, not retroactively. So again, I would just ask that you affirm Judge Summerhays' ruling and simply do the right thing by these Texans. They're doing the best they can do to protect themselves, their homes, their families, and I just ask that you be responsible and interpret and make your decision based upon the laws that have been in place since 2012. That's almost 10 years, and I just would request that you do the right thing and follow the law that's been in place and get the measure corrected for future cases. But thank you so much for what y'all do for the state of Texas. I know you have a tremendous responsibility. The good news in Texas is we have a lot of commerce going on. We're very fortunate for all of the construction that takes place all over the state. So I know the positions y'all are in, not your specific seats, but I've been around for a long time, and I know when a lot of times when you have targets coming from both directions, and so I know how difficult it can be when you have the level of success that Texas is having at the state with regard to construction. And obviously construction requires cement. I get that. I totally understand it. And I think our state is leading in, from a regulation standpoint. There's a reason people want to come to Texas, and the people sitting on this dais is a big part of that, because you have the responsibility of making fair rules for everyone. And I'm going to leave it with that. Just do the right thing and be fair to these folks that have done the right thing in trying to defend their property. So thank you very much for the opportunity to speak to you this morning. I know it's a third time, and I know y'all spent a lot of time on it. So thank you, and may God bless you, and God bless Texas.
Thank you, Representative Cook. Appreciate you sharing your thoughts with us this morning, being with us, and I appreciate your perspectives. I do want to take a moment just to share my reflections on the 3 points that you and Representative Tinderholt made. Firstly, in terms of the perception or notion that we have an agenda to issue the permit. My agenda has a few parts. First is to answer the question: is this authorization protective of the public, and is it issued consistent with the law? So that's the analysis specific to this authorization. But in addition to that, I have an eye towards how what we do here is going to affect the our regulation in this area. What will it do for the orderly administration of these types of authorizations? So I'm looking at the merits of this particular authorization and how what we do here is going to affect the larger administration of our regulatory programs. In terms of the perception that there may have been an open meetings violation, I can assure you there was not. What happened during the last agenda when we took a break is I can't speak to what my fellow colleagues did. I imagine they did the same thing that I did, which was to get a drink of water, wait until our attorneys were available, and have a one-on-one sidebar with our lawyers. I did not meet with either of my colleagues, and I'll also say that the Open Meetings Act is something that we are extremely sensitive to in the agency. We are talking about both that and the ex parte prohibition certainly on a weekly, almost a daily basis. So those two ethical obligations are always at the front of our minds. So I regret that there was a perception that there may have been an unannounced executive session, but I just wanted to let you know that there was not. And then finally, in terms of the idea of sort of changing the rules midstream, I want to try to tease this out and address it. We are reviewing this application under the 2012 concrete batch plant standard permit requirements, period. Now, separately, there is an effort to adopt a replacement concrete batch plant standard permit. That's a conversation that's not before us. It's for another day. It has no bearing on what we're doing today. Now, in terms of what we're doing with the concrete batch plant standard permit is we are interpreting that permit. We're interpreting our rules related to that permit. And so it's not changing the rules or rewriting the rules. It's asking the question, what in the world do these rules mean? And in just a moment, I'll share with everyone my thinking on this and what I think the rules mean, and then I'll hear from my colleagues, and we'll see where we land on it. But I do very much appreciate both Representative Cook and Representative Tinderholt sharing their concerns and their perceptions, so that we could have an opportunity to address them, and very much appreciate your participation. So let me lay out my analysis of this topic. We'll see if it meshes up with my colleagues or not, and then chart a path forward on this. So since our last agenda, I have carefully re-examined the arguments and the potential paths forward on this matter, and I've returned to the same place, which I announced at the last agenda, and that is that we should, in fact, overrule the administrative law judge on the interpretations of sections 116.610 and 106.261, and that means granting the authorization. And I'm going to speak to three topics. The first is the protectiveness of the standard permit. The second is the policy implications of our decision, and then finally my thoughts on how we should interpret the relevant rules. So, as I alluded to a moment ago, first and most importantly, this authorization is protective of the public health and the environment. And to be clear, it's protective without the complete prohibition on silica emissions that the protestants urge. Protectiveness has been demonstrated with each iteration of the standard permit, and standard permits generally, including this concrete batch plant standard permit, are adopted under section 382.05.195 of the Federal Clean Air Act and under chapter 116 subchapter F of TCEQ's rules. And those authorities, they're somewhat redundant, but those authorities require appropriate pollution controls for the authorized activity, as well as public notice and comment. And the current concrete batch plant standard permit to meet those requirements, together with earlier iterations of the concrete batch plants, in order to meet the requirements of those two legal authorities, they limit production rates, they require setbacks, they include both performance and technology-based pollution controls, and these are controls that target particulate matter, which includes crystalline silica. So the protestants have noted correctly that the protectiveness review for the standard permit did not expressly address crystalline silica. And I do want to be clear that contested case challenges to a specific standard permit are to determine compliance with that standard permit, not the adequacy of the standard permit. So an attack on the adequacy of the standard permit would be, what we would call a collateral attack. That said, the hazards of crystalline silica have, for decades, been well understood to come from inhaling particulate matter that contains or consists of crystalline silica. So it was well understood at the time the concrete batch plant standard permit was adopted that by controlling particulate matter, the standard permit is controlling crystalline silica. And that judgment that the standard permit would be protective is borne out by experience. I've seen no evidence to indicate an issue with crystalline silica emissions at any facility that's complying with the concrete batch plant standard permit. It just simply hasn't been an issue. I expect to see more explicit analysis of crystalline silica as the part of future concrete batch plant standard permits, but the current standard permit and its earlier iterations have nevertheless been protective, including with respect to crystalline silica emissions. And if there were an indication that a more explicit analysis would lead to more stringent controls, I may view this differently. That is simply not the case. So that brings me to the policy implications. Protestants argue for a legal interpretation of 116.610 and 106.261 that would prohibit entities authorized under the concrete batch plant standard permit from emitting any crystalline silica. And since crystalline silica is inherent in the concrete batch plant process, such an interpretation would effectively nullify the concrete batch plant standard permit, and it would create considerable regulatory uncertainty for the community that's currently authorized under those permits. In addition, as I suggested before, entertaining that interpretation would be second-guessing the agency's prior determination on protectiveness, and we'd be doing so absent any new concerns about whether the standard permit is actually protective. So as it relates to policy, I think there is a strong case against the protestants' interpretation. All right, I've talked about protectiveness and I've talked about policy, and that brings me to the final topic, which is our legal interpretation, and that is how should we read the relevant rules? Not changing the rules, but how do we interpret our rules in this context? And the question is this: does section 106.261A3 establish an emission limit of 0 for crystalline silica, or are such emissions simply outside the scope of that particular permit by rule? Reading the rule as a complete prohibition, as the protestants have encouraged us to do, would, for practical purposes, render the concrete batch plant standard permit useless, and that would be an absurd result. Moreover, the protestants' interpretation doesn't track with the actual language of the rule, which states that such emissions are, quote, not allowed under this section. So that language does not establish an emission limit, it defines the scope of the rule. And as a matter of practice, emissions not allowed under 106.261 are routinely authorized under a different permit by rule, such as 106.262. That's a practice called stacking. Regulated entities will stack their permits by rule. So in this case, the crystalline silica emissions are authorized by appropriately controlled through the standard permit itself, which sets out the operational requirements that I mentioned earlier, which limit particulate matter, including crystalline silica, and the bottom line is that it's protective of public health and the environment. And I'm satisfied that the applicant has shown that it would comply with those operational requirements. And given this, what I think is a very reasonable interpretation of our rules in the standard permit, I don't think we should accept the protestants' interpretation. It's wholly unnecessary with respect to protectiveness. It's absurd with respect to its practical effect on the standard permit and the effects that it's going to have in our administration of the regulations in this area. And really threatens to throw the agency's administration of these standard permits into disarray. And again, I don't think we should entertain collateral attacks on the standard permit. I think the Commission should exercise its discretion to interpret the rules in a manner that is protective of public health and the environment, and that supports coherent and orderly regulation under the standard permit. And in my view, that requires us to overturn the ALJ's conclusion that the concrete batch plant standard permit includes a complete prohibition on crystalline silica emissions. So, colleagues, those are my thoughts. I was long-winded, I apologize for that, but I wanted to just lay out real clearly for the record and for the people tuning in why I arrived at the conclusion and decision that I've arrived at. I want to hear your thoughts and also just remind you that we have parties signed in to speak. So if you have any questions, we can ask those questions. So I'll be quiet, and Commissioner Lindley, I'll invite your thoughts.
Well, thank you. And I'll ask one quick question to Mary. Do those folks get to speak today, or is it only if we have questions?
Only if you have questions.
Okay. I didn't want to cut anyone short. I do have thoughts, and like you, jotted them down, so I'll probably end up reading them more so because this one's so
It helps.
tricky and challenging. Yes. I'll just start by saying that this one has been extremely challenging for so many reasons, which we can all agree with. You laid out all of them very well. I came down differently. I'm on it's kind of a windy path to get here personally, but I'm in agreement with the ALJ, and that I think for this application we need to deny it. And my reasons aren't quite as long, but I will read them off, and if I'll just do that, and hopefully it'll be clearer that way. Bottom line, I think the applicant, Bosky, they failed to demonstrate that its proposed facility is going to comply with crystalline silica emissions, established in the rules. I think that based on the current language in the standard permit for a concrete batch plant, the rules applicable to standard permits directed applicant to comply with emission limits in 30 TAC 106.261. I'm just struggling on talking today. Chemicals with a limit value of less than 200 milligrams per cubic meter, including crystalline silica, are not allowed under that section. Emissions of crystalline silica can be authorized under 30 TAC 106.262, but while our rules do authorize these emissions at certain levels, I agree with the ALJ that Bosky failed to demonstrate that its proposed facility will comply with the crystalline silica emissions limits established in either 106.261 or 106.262. To be very clear, I believe that the standard permit is protective of human health and the environment. I just think the evidentiary record would have and should have been more fully developed regarding crystalline silica emissions. And I believe it's very possible it would have been shown that any potential crystalline silica emissions at the facility would be below the effects screening level and protective of human health and the environment. However, nevertheless, since the current standard permit references rather than exempts compliance with sections 106.261 or 106.262, today I'm not comfortable overturning the ALJ and granting the application. I just don't think they demonstrated compliance with the rules. So, in summary, I took a very plain reading interpretation of the rules is how I would say it. And so where I am today, and I might be the Lone Ranger, I don't know, but that's where I am.
We're about to find out.
Take it away.
Commissioner Janeka, you have two very different readings of 106.261.
Well, I appreciate the discussion, and I appreciate y'all laying out in very thoughtful detail all of your prepared remarks. I don't have anything nearly so well thought out prepared, so I'm going to stumble through it as best I can. Probably speaking much more to the layman public out there, I'm sure watching with much interest. I'll just say that I follow your thinking, Chairman, and I agree with it up to the point of getting up to the edge of the cliff, that precipice of looking at the record before us and looking at the arguments and the discussion that occurred before the ALJ's ruling and what comes before us. I don't think that I see a demonstration in that record that that following section, which I agree with you, does provide a clear regulatory space for applicants under the current 2012 concrete batch plant standard permit to demonstrate that their processes would meet those rules, even absent the language that were inadvertently failed to be preserved and transmitted from the technical requirement section of the standard permit in 2012 to the administrative requirement, or vice versa. I forget exactly which, but for that clear exempting language in there, I think that the demonstration of 106.261 and 106.262 needs to be made. I don't see the demonstration of that latter section in the record, and I don't see that. I don't see a very high compelling public need served in remand. I'm not sure that absent the demonstration in the record, I just can't quite get to issuance over the bad optics and partly of which I think our agency needs to acknowledge the role and those effects of all the ancillary processes. And I appreciate you laying out in detail at the beginning of this, taking up this matter that I think was well stated, the administrative process. And I think of our standard permit as high occupancy vehicle lane on the highway of environmental regulation, and where other vehicles will be taking all the general public lanes, and they may have to prove up and meet the requirements for their individual vehicles tailored to those individual roads. If you want to drive on this fast lane, you can do so within the confines of that standard permit. And we do a very robust demonstration at the front end of the standard permit and set meets and measures within that box, rather than asking for the demonstrations to be made case by case. And so I agree with you that there is a real public interest in preserving that those administrative processes. I think that it pushes me right up. And hearing each of y'all, I was on the fence a little in terms of whether the appropriate path forward would be or could be remand or denial. I think I'm more in agreement with Commissioner Lindley only on review of the record and not seeing very specific demonstrations speaking to 106.262.
Thank you, Commissioner. Thank you, Commissioner Janeka. And colleagues, you know this already, but I have a tremendous amount of respect for what you bring to this commission, and so I'm going to respect the work that you put into this and not try to talk you out of it. I reached a different conclusion. It sounds like I'm in the minority, so I think I'll invite either more comments or a motion consistent with the position that I think the two of you have landed on. And I just want to make a note that I got a message that my mic is not picking up well on some channels, but is picking up just fine on others. So if you can't hear me, I apologize. If it seems like I'm comically loud, that's why I'm being comically loud, is that some people can't hear me as well. So I'm going to be screaming at you for the rest of this agenda, which should be a lot of fun for all of us. So with that, colleagues, I'll entertain another any other comments or a motion.
I have a motion. I have a motion I can attempt. It is a little long because there are a number, I think about 14 or so conclusions of laws that need to be tweaked. So I will try and read it slow with the hopes that I, one, get it right since I'm tripping on words today. And two, if I get it wrong, you can correct me right then and there so I don't have to reread the whole thing a second time. So I will try to go slow, but flag me if it sounds like something I've said is inaccurate. So I will move that we adopt the ALJ's proposed order with the following changes. A, amend finding of fact 15 to replace January 17th, 2020 with February 14th, 2020 for accuracy. B, amend finding of fact number 29 to replace 2001 with 2000 for accuracy. C, amend finding of fact number 63 to state the CBP standard permit requires concrete batch plants to demonstrate compliance with 30 TAC 106.261 and 106.262 to reflect TCEQ's interpretation of its rules. D, amend finding of fact number 64 to add the word % after the number 70 to correct a clerical error. E, amend finding of fact number 68 to state emissions of a chemical with a limit value of less than 200 milligram per cubic meter are not allowed under 30 TAC 106.261. However, these chemicals may be authorized under the emissions limits in 30 TAC 106.262 to reflect TCEQ's interpretations of its rules. F, a finding of fact number 69 to state Bosky failed to demonstrate that emissions from the sand used at the plant would meet the emissions limits for crystalline silica required under 30 TAC 106.261 or 106.262 to correct the ALJ's misunderstanding of the legal difference between an effect screening level and an emissions limit to replace ESL with the correct legal term. G, effect finding of fact number 70 to state long-term exposure to crystalline silica emissions may pose a danger to human health and safety. The applicant did not present sufficient evidence to demonstrate the amount of crystalline silica that would be emitted from the proposed plant to more accurately reflect the evidence in the record.
Commissioner?
We have a hand
Yep.
went up over
What did I
here.
say?
If I could stop you, you asked me to. I'll just
Yes.
ask to clarify on, in this motion, on the change in item F and item G. I just wanted to confirm. I think I heard finding of fact number 70 on the last one, your motion includes language to amend finding of fact number 69 and amend finding of fact number 70?
That is what I would like to say, is amend, yes. Finding of fact number 69 and amend finding of fact number 70.
Thank you.
Is that clear? Okay, thank you. Moving on, H, amend finding of fact number 71 to replace the capital A in the citation with the lowercase a to correct a clerical error. I, amend finding of fact number 77 to state, other than not providing sufficient evidence regarding the emissions of crystalline silica, Bosky demonstrated that the plant would, 1, not negatively affect air quality, and 2, be protective of general welfare, including animals, vegetation, and the environment. Protestants failed to rebut this showing. That was a quotation. I don't know if I should have clarified that. That quotation ends after the word showing, to better conform to the finding of the ALJ's conclusions of law and more accurately describe the evidence in the record. Am I okay with that one? Okay. J, amend conclusion of law number 12 to state, the CBP standard permit requires the applicant to demonstrate that it meets emissions limitations in 30 TAC 106.261 or 106.262 to more accurately state the applicable law. K, amend conclusion of law number 13 to state, Bosky failed to demonstrate that the plant will be constructed and operated in accordance with the emissions limitations of 30 TAC 106.261 or 106.262 to more accurately state the applicable law. L, amend conclusion of law number 16 to state Bosky did not demonstrate that the crystalline silica emissions from the proposed plant would be authorized under 30 TAC 106.261 or 106.262 or any other applicable TCQ rule to reflect the agency's interpretations of its own rules and more accurately state the applicable law. I'm almost done. M, add new ordering provision number 3 to state, the executive director's response to comments is hereby adopted to the extent it is consistent with the commission's decision and final order in this matter pursuant to 30 TAC 50.117 and renumber the remaining ordering provisions. And N, amend the signature block of the order to reflect the name of the current chairman. And finally, that we adopt the executive director's response to comments to the extent it's consistent with the commission's decision and final order on this matter.
I second that motion.
Motion has been made and seconded. All those in favor say aye.
Aye.
And I oppose, so this is a rare decision that's not unanimous from this dais. But with that vote, the motion carries. Thank you, colleagues. The next item would be old business number 2, but we're going to take that up with the enforcement docket later in the agenda just for efficiency. So, Ms. Smith, when you're ready, I'll ask you to call item 1.
New business, item number 1, is consideration of the ALJ's proposal for decision and proposed order concerning the application of Crystal Clear Special Utility District and MCLB Land LLC for new TPDES permit number WQ0015266002. The applicants should go first, followed by the protestants, the ED, and OPIC in that order. By letter dated May 21st, 2021, the chief clerk, at the request of the Office of General Counsel, provided the following oral argument time limits. Applicants, 8 minutes collectively. Protestants, 8 minutes collectively. ED, 5 minutes. And OPIC, 5 minutes. The applicants may save some time for rebuttal as they bear the burden of proof on the application.
And I understand that Ms. Gilbert may be with us for the applicant. Are you there?
I am, Chairman. Can you hear me?
Loud and clear. Please go ahead when you're ready.
Great. Good morning, Chairman, Commissioners, General Counsel. I'm Helen Gilbert, and with me today on the line is Shan Rutherford. We represent co-applicants MCLB Land LLC and Crystal Clear Special Utility District. After more than 3 years since filing the application, applicants are pleased to be here this morning in support of the proposal for decision, the proposed order as amended by the ALJ, and the positions taken by the Executive Director and the Office of Public Interest Counsel. They are correct, Commissioners. The applicants have shown by a preponderance of the evidence in the record that the draft permit meets all state and federal legal and technical requirements on all 9 referred issues, and the TPDS permit should be issued without changes. At the same time, protestants put forth no probative evidence that one or more provisions of the draft permit violate an applicable state or federal requirement. Of the 9 referred issues, protestants focused on water quality and regionalization and only marginally addressed or didn't address at all issues like odor, compliance history, or impact to groundwater. Let me address those 2 main areas briefly. As to water quality, applicants are proposing tertiary treatment. That's the most stringent effluent set the Commission normally issues of 5521. The site will be served by Crystal Clear, who has been an established utility for more than 60 years. Crystal Clear has the highest compliance history ranking the agency issues. The ED's water quality model, the CSTR, and the applicant's modeling expert both confirmed that the discharge will not violate the state's anti-degradation policy. The proposed permit limits are stricter than required by the surface water quality standards. And ironically, I want to point out the City of San Marcos opposes applicants' proposed effluent set, even though those limits are the same as those in the city's own permit. Turning to regionalization, this was really the City of San Marcos' primary focus in this case. And the takeaway here is the incongruity of the city's position. On one hand, it urges you to deny the permit so the city can step in and provide service within Crystal Clear's boundaries. Yet the city denied applicants' request for service. The city stated, quote, "We will not support extension of city wastewater service without annexation." Let me repeat that. We will not support extension without annexation. Because the legislature has stripped the city's ability to unilaterally annex property, this city has used wastewater service as a means of circumventing that prohibition. And the city has employed a similar strategy in multiple other TCEQ cases. We would submit to you, Commissioners, and the ALJ, ED, and OPIC agree, denial of this permit on the basis of regionalization is not warranted under Section 260282 or 081 of the Water Code. The PFD is correct that those statutes state permissive goals to encourage and promote regionalization. They do not mandate it. But we want to underscore something very important. Service by Crystal Clear actually will further regionalization. Crystal Clear already has the water CCN for this site and serves multiple standalone sewer systems in its Tri-County area. Meanwhile, the city has no sewer CCN for this site, and its own out-of-city extension policy explicitly states, quote, "City wastewater is only available to city water service customers. The city has no legal authority to provide water service to the site, and the city providing sewer service would only violate its own extension policy." Finally, a word about protestants' last-minute request to reopen the record. Here, too, we support the PFD and the ALJ's 7 prior evidentiary rulings dealing with these issues. Protestants' demand simply ignores the fact that there is no re-rebuttal for protestants in a post-Senate Bill 709 process, which is intended to last only 180 days. The protestants had all the process they were due in this case, and the evidentiary issues have been well litigated. I would also like to add, finally, touch on something that Commissioner Lindley said earlier. This TPDS permit is not tricky or challenging. It's straightforward. Applicants complied with the rules, and then we went above and beyond. Applicants MCLB and Crystal Clear respectfully request that you adopt the proposal for decision. We'd like to reserve any extra time for rebuttal, and we're happy to answer any questions you might have. Thank you.
Thank you, Ms. Gilbert. Looks like you have about about 2 minutes and 53 seconds for rebuttal if you want to use that. I don't have any questions for you. Colleagues, any questions? Commissioner Lindley?
No questions. Thank you.
Commissioner Janeka?
Likewise. No, thank you.
All right, we'll hear next from the protestants. I understand that the protestants will be splitting their argument, so I'll just leave it to you to introduce yourselves, identify yourselves, who you represent, and the floor is yours when you're ready.
Good morning, Commissioners. My name is David Flores. I represent the protestants. Thank you for the opportunity to address the Commission today. I am speaking to you as a professional aquatic scientist, a former TCEQ Water Quality Standards employee, and a concerned Texas citizen. TCEQ's draft permit is not correct. Let me state that again. The draft permit is not correct. TCEQ staff based their technical review on desktop information and assumptions which do not accurately represent existing receiving water conditions. TCEQ had an opportunity during the administrative process to consider site-specific data our team collected, but failed to do so. As you know, TCEQ's entire analytical evaluation of the proposed discharge relies on one important step, the designation of a stream's aquatic life use. The TCEQ misclassified the receiving water body's aquatic life use by not collecting site-specific data and or considering site-specific data collected by our team. The site-specific data provided two important facts which directly contradict TCEQ's staff's assumptions. First, the aquatic community is more significant and sensitive than TCEQ assumed. Thus, more stringent water quality standards should have been used during the technical evaluation of the draft permit. And second, the current stream conditions of the discharge point show excessive aquatic vegetation growth, which indicate high nutrient loading already exists. Therefore, to meet the Texas water quality standards and to protect our natural water courses, my recommendation is for the denial of this draft permit. Thank you.
Thank you, Mr. Flores. Colleagues, any questions for Mr. Flores?
No, none for me. Thank you.
Commissioner Janeka? All right, protestants, I'll ask you to proceed.
Good morning. Thank you for the opportunity to address the Commission today. My name is Tim Osting. I'm an engineer who conducted a site visit to the receiving stream for the protestants, Mr. Carson. I also reviewed materials used to develop the draft permit. This draft permit relies upon a water quality model developed by TCEQ staff based upon the permit application, rather than based upon available on-site data. The model is an integral part of draft permit development, and that model contains significant deficiencies. As one example, TCEQ's model volume in the stream is nearly 200% of the real-world volume based on on-site depth data. The model volume is important because real-world volume is important. In the real world, there's nearly no natural base flow in this intermittent stream with perennial pools. As soon as a discharge commences, nearly all volume in the real stream will be comprised of effluent. In the model, such a large input error corresponds directly to a large output error in residence time, velocity, reaeration, location of dissolved oxygen sag, and downstream concentration of biological oxygen demand, ammonia, and dissolved oxygen. This model with errors should not be relied upon for whether the permit meets any de minimis anti-degradation requirement. TCEQ's model has errors, making it very different from the real world, and should not be relied upon for evaluating conformance with Texas water quality standards. I recommend the Commission deny this permit. Thank you.
Thank you, Mr. Osting. Colleagues, any questions for Mr. Osting?
No questions. Thank you.
Seeing none, go ahead. Next up.
Yes, my name is Chris Carson, and my family owns the 852-acre ranch just downstream of the proposed discharge point for this treatment plant. Our primary concern is the potential impact the facility could have on our ranch operation, our livestock, and our property value. We presented an abundance of evidence that conditions on the ground are different from what was presented by the applicant and evaluated by TCEQ. As a sixth-generation Hays County resident and one of the largest private landowners in the area, I'm asking you to please take a hard look at this permit and the information we provided. The city of San Marcos provides wastewater service to the residential project across the street and is capable of serving this development as well. There's a stub out less than 200 feet away. The city discharges 0% of its treated effluent on the private property, and 100% of the effluent from this plant will cross our ranch and end up on the 180-acre flood control reservoir on our property. As a private landowner, I'm being asked to bear a considerable and exclusive risk created by this unstaffed facility operated by a rural water provider with very little wastewater experience. I want to be clear that I'm not against the residential subdivision being proposed for this property, as I'm also an active Central Texas land developer, having participated in numerous projects over the last 25 years. But this is not the hardship case the legislature envisioned in allowing package plants for projects that were being held hostage by CCN holders demanding unrealistic and costly utility extensions. This is an unfortunate example of a developer taking advantage of an otherwise well-intended process. Thank you.
Thank you, Mr. Carson. Colleagues, any questions for Mr. Carson?
None. Thank you.
Thank you. Next up. And I think I think Mr. Rodriguez may be left, but I can't hear you, sir. You might double check to make sure you're not muted. Still not hearing anything. Mr. Rodriguez, are you with us?
It looks like he's trying to dial in now. He was on.
Tell you what, we'll pause for a moment and give him an opportunity.
Can y'all hear me now?
Oh, here we go. We've got you. Yes. Thank you.
Uh,
Good morning,
my-
Mr.
my
Rodriguez.
Good morning, Commissioner. Mr. Chairman, thank you for recognizing me. I'll go ahead and start now. And I provided a map to Ms. Tack. If she could put that up on the screen, I'd appreciate it.
Great.
My name is Art Rodriguez with the law firm of Russell Rodriguez Hyde Bullock, and represent the city of San Marcos in the application before you. The city is quite disappointed in the PFD and requests denial of the permit application on many grounds. First, the Texas legislature has made it the policy of the state to look at regionalization issues in a substantive manner and states it twice in Chapter 26 of the Water Code. It is important to take a look at regionalization with this map, and that's admitted in the record. The map shows you the relation of the applicant's property to the city of San Marcos' existing system, not proposed system, but existing system. The map shows that the city has existing infrastructure approximately 175 feet from the applicant's property. The evidence shows that the city's existing capacity and infrastructure provide service to the applicant, which would prevent another source of pollution into state streams and recreational waters. The ED staff stated repeatedly that regionalization is important to the state policy, yet the staff member in this case, who has performed 500 regionalization reviews, never sought to perform a cost comparison in any of those cases to determine which system would better serve the environment. The ED staff relies solely on a statement that the city's requirement to annex as a condition of service was tantamount to a denial of service. Yet it is clear that the ED staff disagree on what service conditions, other than annexation, would also give pause to the commission as to a denial of service. The point is, there is no policy, practice, procedure, or guidance that informs utilities what conditions of service will give rise to the sua sponte declaration by the ED that a service condition is a denial of service. In short, the regulated community has no notice of the ED's review procedures. This sort of ad hoc analysis, which can be expansive and restrictive depending on the reviewer, is ad hoc rulemaking. The result is that it provides zero guidance to the regulated community as to what is allowed and what is not allowed. For an agency that prides itself on clear and consistent policies, this ad hoc rulemaking and lack of clarity potentially results in permitting more sources of pollutions into the waters of the state. The agency should be moving toward a more predictable regulatory process and not a process that depends solely on who the reviewer of an application is. Further, there is lack of consistency in the review of the Commission's own application for discharge permit. The application and instructions for the application clearly state that in order to do a proper regionalization review, an applicant must produce certified letters to sewer systems within 3 miles of the proposed facility. The city is clearly within 3 miles, as the map demonstrates. In this case, the applicant failed to produce a certified letter or certified response from the city. The ED staff and ALJ both admit that a certified letter was not provided. The PFD provides that the applicant substantially complied, which is an admission that compliance was not provided. Finally, this case is a clear-cut case that reliance on commission precedent in the Midtex Partners case should be followed. The commission adopted conclusions of law in Midtex that demonstrate a very strong policy favoring regionalization. No
That's
case
time.
is more clear-cut that screams for TCEQ to reiterate its commitment to the environment than this one, which would prevent another source of pollution when a real solution is only 175 feet away. Thank you, Commissioners.
Thank you, Mr. Rodriguez, and appreciate the presentation. Colleagues, any questions for Mr. Rodriguez? All right, seeing none, and I do especially appreciate, Mr. Rodriguez, your observations about the lack of guidance around what regionalization means. However, I need to. I was about ready to launch into my analysis, but I need to afford Miss Gilbert her 2 minutes and 53 seconds. I apologize. Go ahead when you're ready, Miss Gilbert.
Chairman, are we waiting for the Executive Director and Office of Public Interest Counsel?
We are. You know, I'm back at the dais for the first time in over a year, and I guess I'm feeling a little rusty on this. But thank you for keeping me on track. We will hear. Thank you, Ms. Gilbert. We will hear next from the Executive Director.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. My name is Bobby Salahi with the Environmental Law Division. With me today are Feroz Bahora and Peter Schaefer of the Water Quality Division. The Executive Director agrees with Judge Henderson's PFD to issue the draft permit in this case. The exceptions we noted were all addressed and accepted by the Administrative Law Judge. Thank you, and we're available for any questions you may have.
Thank you. I have none. Colleagues, any questions?
No questions. Thank you.
None for me.
Seeing no questions, we'll hear next from the Office of Public Interest Counsel. Good morning, Mr. McWhirter.
Good morning. Vic McWhirter, TCEQ's Public Interest Counsel. OPIC agrees with the findings and conclusions of the Administrative Law Judge on the 9 issues the Commission referred to hearing. From the record, it's clear that the most disputed issues are whether issuance of the permit would be contrary to the state's regionalization policy and whether there's a need for the permit. As noted in the PFD, there are no agency rules on regionalization, and the Commission may exercise its discretion to encourage and promote regionalization based on the evidence presented on a case-by-case basis. We agree with the statement on page 33 of the PFD that the purpose of the regionalization review is to encourage applicants to give serious consideration to available service in the area, not to provide neighboring utilities leverage and means to require connection. OPIC's position is that the regionalization policy does not compel applicants to accept every condition an alternative service provider may impose, such as the conditions at issue here regarding annexation and compliance with the city's land use codes. The evidentiary record in this case supports the judge's recommendations on the regionalization issue and the issue regarding consideration of need, as well as the other referred issues. OPIC recommends adopting the proposal for decision, sustaining the Executive Director's exceptions to make minor corrections, and adopting it as modified. Thanks, and I'm available for any questions.
Thank you, Mr. McWhirter. I have none. Colleagues, any questions for Mr. McWhirter?
No questions. Thank you.
Seeing none, now, Ms. Gilbert, it's your opportunity. Thank you again for keeping me in line here, and you have 2 minutes and 53 seconds.
Great. As to Mr. Osting, let me point out he is not an attorney. He testified more this morning than he did in the hearing, as did Mr. Flores. Both touched on items that are outside of the record, specifically the excessive vegetation and the 200% reference. What you need to know is that their analysis was partial. It was summary only. We did not receive half of their model, the input data. We received very little of their site-specific data. We received no modeling runs at all from protestants. They violated the implementation procedures. They applied a 7-day, not 30-day average. And they simply, more data will not overcome the fact that they used the wrong methodology in looking at this application. As to Mr. Carson's statement about the unstaffed, supposedly unstaffed treatment facility, Crystal Clear has a Class A operator with over 30 years of experience, and would operate a very sophisticated MBR plant. As to regionalization, the only registered professional engineers who testified in this matter looked at the city's as-built plans. Saying there's existing infrastructure is not the same thing as capacity in that infrastructure. The lift station near the facility is simply not sized for this subdivision. It serves 2 other communities. A cost comparison was not required by staff. That was the finding of your 24-year permit writer and his 30-plus year manager, Mr. Vahora. The cost comparison was not required, but was only provided as Section 80.17 additional evidence. It's clear the city's problem here really is addressable by rulemaking or legislation, but not by denial of this permit. The certified letter also, as we indicated in our exceptions, is making a mountain out of a molehill. There was plenty of communication with the city. There is email correspondence that memorializes that. It was the culmination of months of effort. The culmination of that effort was the city's demand that we annex at a price tag of additional $3 million for this facility. Finally, Mid-Tex is inapplicable. It was a TLAP case, and that facility was already annexed. It's a 14-year-old case that has no applicability here. Thank you, Commissioners.
Thank you, Ms. Gilbert. Colleagues, as you know, the ALJ is in the best position to evaluate the weight of the evidence and the credibility of the witnesses, and we can't simply overturn the ALJ's findings unless we identify an error, a clear error, nor can we overturn a conclusion of law unless the ALJ has misinterpreted the law. Having reviewed this matter, I find no basis to overturn the ALJ. It appears to me that the applicant has met its burden on the water quality issues, on need, and on regionalization, on compliance history, and so on. So I think we should adopt the PFD with the clarifications agreed to by the administrative law judge and grant the application. As a sidebar, I do think it would be helpful for the agency to develop some new guidance on regionalization and on the policy of need. And I'd simply invite staff to meet with me about that. So those are my thoughts. Commissioner Lindley, what do you think?
I'm in full agreement on all your comments, actually. So,
thank you, Commissioner Janeka.
I can't improve those prior comments. I'll simply make a motion if the two of y'all are ready. I will move that we adopt the ALJ's proposed order as amended by the ALJ's letter dated April 27, 2021. Grant the permit application of Crystal Clear Special Utility District and MCLB Land LLC for TPDES permit number WQ00152-66002 and adopt the ED's response to comments.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries.
Chairman, can I ask for a 2-minute, 3-minute pause, recess, whatever we...
Yes. Why don't we make it 5 minutes and round to nearest 5 minutes. The time is 10:39. We will stand in recess until 10:45. Colleagues, the time is 10:45 a.m. and we're back on the record after a short break. Ms. Smith, when you're ready, I'll ask you to call the next item.
Item number new business 2 is an application by Ineos Nitriles USA LLC for amendment and renewal of Texas Pollutant Discharge Elimination System permit number WQ00021810000. The parties have been notified that the commission will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Thank you, Ms. Smith. For the benefit of those who are unfamiliar with our process, and I'm, for reasons I've already explained, I'm going to try to continue to speak in a comically loud fashion. But for those who are not familiar with our process, we have a two-part analysis for considering requests for contested cases. First, we consider whether the requesters have met the procedural and substantive requirements to be entitled to a contested case. And assuming at least one requester has done that, we then consider which issues are appropriate to refer for hearing. So part 1 is about who gets a hearing, and part 2 is about which issues are referred. And I'll get to that analysis in a moment, but there is a threshold issue that is occasionally raised, and it's been raised here, and that's the so-called no increase renewal. Under 30 Texas Administrative Code, Section 55.201I5, there is no right to a contested case hearing for permit renewals that do not increase the amount of authorized effluent, among other requirements. Ineos has invoked the provision. However, that rule also requires that there be no material change to the pattern or place of discharge. Ineos seeks to authorize new outfalls for storm and hydrostatic test water that have the potential to affect neighbors who are not affected under the current authorization. So I think that Ineos has gotten close but has not quite met the no increase renewal exception, which would take me to our normal analysis. But let me pause there and see if my colleagues came out in the same way. Commissioner Lindley.
I'm in agreement.
Commissioner Janeka.
Entirely in agreement as well.
All right, turning back to our two-part analysis, requesters who are affected in a manner different from the general public, who have articulated personal concerns that are relevant and material to the permit and have done so in timely comments and a timely hearing request, are entitled to a hearing. We have a single requester in this case. There's no real dispute that Mr. Adams' property is sufficiently close to give rise to a personal justiciable issue. The question is whether he has actually articulated a personal issue. I think he has, by expressing concerns about the negative impact this authorization may have on his use and enjoyment of his property. He also expressed concerns about water quality. I think those are more or less one and the same, but he did personalize it in speaking about his own use and enjoyment. So I do believe that Mr. Adams has demonstrated his right to a contested case hearing. Any objections to that? Commissioner Lindley?
No, I agree.
Commissioner Janeka? All right, seeing none, we'll turn to the issues. And again, for the benefit of those who are not familiar with our process, we refer issues of fact that have been timely raised by an affected person and that are relevant and material to the application. And in this case, I would organize Mr. Adams' referable issues into two issues. First, whether the draft permit is protective of water quality in the receiving waters, and second, whether the draft permit will adversely affect the use and enjoyment of the requester's property. Commissioner Lindley, how does that sound?
Those two issues are how I came down as well.
Commissioner Janeka? All right, I think we're ready to entertain a motion.
I will make one little comment. You know me, I like to speed things up if at all possible. I don't know how y'all would think about potentially trying to shorten this one, since it's one person and only two issues, to a referral of 150 days. I'm just tossing it out there. I don't know.
Sounds reasonable to me. Commissioner Janeka?
No objections there.
Okay, well then I will make a motion. I will move that we grant the hearing request of Adam Adams, and that we refer the matter to SOA for a contested case hearing on the following issues. A, whether the draft permit will be protective of the water quality in the receiving waters under the applicable Texas Service Water Quality Standards. And B, whether the draft permit will adversely affect the use and enjoyment of the requester's property. and that we specify the maximum duration of the hearing to 150 days from the preliminary hearing to issuance of the proposal for decision.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries.
Item number 3 is application number 13679 by Select Energy Services LLC for a temporary water use permit to divert a maximum of 387 acre-feet of water within a 3-year period from Cibolo Creek in the San Antonio River Basin. The parties have been notified that the commission will not take oral argument but may ask questions. Those who have signed in will be noted for the record.
Thank you, Ms. Smith. Our analysis for requests of contested cases on water use permits are a little different than they are in a typical 801-709 request in that there's essentially one step. If a requester demonstrates affected party status, they're granted a hearing without referring specific issues. In making that determination, the Commission is guided by 30 Texas Administrative Code Section 55.256C, which sets out factors similar to our analysis of House Bill 801 and Senate Bill 709 hearings. We have 4 requesters in this case. ADD Corp. or Ad Corp. Request was not timely. The remaining requests were timely, and each of these requesters hold water rights downstream of the proposed diversion point. That's a clear case for affected party status in my view, and I would grant those requests. Colleagues, how'd you come out? Commissioner Lindley?
I'm in agreement.
Likewise.
And what are our thoughts on ADR and ADR referral in this case?
I think it's worth a shot. Yes.
I think we're ready to entertain a motion on item 3 then.
Mm-hmm. Good. I will make the motion that we grant the hearing requests of Clifford B. Baker on behalf of Baker Family River Farm, the Guadalupe Blanco River Authority, and Zachary X. Yanta and Linda A. Yanta, deny all remaining hearing requests, and refer application number 13679 by Select Energy Services, LLC, to SOA for a contested case hearing with a referral to the TCQ's ADR program to run concurrently with SOA preliminary hearing scheduling efforts.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries.
Item number 4 is application number 13674 by Select Energy Services LLC for a temporary water use permit to divert a maximum of 387 acre-feet of water within a 3-year period from the San Antonio River in the San Antonio River Basin. The parties have been notified that the commissioners will not take oral argument but may ask questions. Those who have signed in will be noted for the record.
Colleagues, this item concerns a very similar application by Select Energy Services, except in this case it is for water from the San Antonio River rather than Cibolo Creek. We have the same 4 requesters, and our analysis is similar but not identical. In this case, AdCorp's request was timely. However, its interest is a water right that is upstream from the proposed diversion and would therefore not be affected. So I think we should deny that request. The remaining requesters were timely, and again, they're downstream. I think it's an easy case, easy call for affected party status, and I would grant those requests. I think it's probably appropriate to include this in the ADR process as well. Commissioner Lindley?
I'm in full agreement.
Commissioner Janeka? All right, we're ready for a motion.
I will move that we grant the hearing request of Clifford B. Baker on behalf of Baker Family River Farm, the Guadalupe Blanco River Authority, and Zachary X. Yanta and Linda A. Yanta, deny all remaining hearing requests, and refer the application number 13674 by Select Energy Services, LLC, to SOA for a contested case hearing with a referral to the TCEQ's ADR program to run concurrently with SOA preliminary hearing scheduling efforts.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries.
That takes us to the enforcement docket, which is old business item number 2 and new business items 5 through 29. The executive director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Brian Sinclair, also of the Enforcement Division, and Charmaine Backens of the Litigation Division, representing the Executive Director. Pending before you are our old business item 2 and items 5 through 29. The total assessed administrative penalties are $279,315, with $29,299 deferred, $85,130 applied towards supplemental environmental projects, and $164,886 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Commissioner Lindley, any questions?
No questions. Thank you.
Commissioner Janeka?
Not at this time.
Thank you. I understand we do have some folks signed in for the City of Laredo on old business item 2. I really appreciate them being here this morning. I do want to comment a little bit on that matter before I invite their thoughts. Administering the Federal Safe Drinking Water Act and helping regulated water systems ensure safe drinking water supply for our fellow Texans may be the most important thing that this agency does from the perspective of public health. It's certainly on a very short list. The effects of contaminated water can be immediate and severe, and there have been some very unfortunate cases that have demonstrated that all too clearly. And because the health effects can be so serious and so immediate, we want to err on the side of caution. And that's a feature of the federal law. If there's potential for contamination, for example, the loss of pressure in a system, we require systems to issue boil water notices. So I take the boil water notices very seriously. I want to make sure that we have an understanding with our regulated entities of the importance of this requirement, and that's where I'm coming from on this one. So. And I don't mean to be picking on the city of Laredo here. It's a great Texas city. I really appreciate y'all dialing in to be with us this morning. I just wanted an opportunity to share that with you directly and to invite your thoughts. And I understand that City Attorney Benavides may be with us. Are you there, sir? And I can't hear you. I'll invite anybody who may be present who wants to speak on behalf of the city to go ahead.
Good morning. This is Arturo Garcia, Director of Utilities for the City of Laredo. Mr. Chairman and Commissioner, thank you very much for allowing me to speak. I understand the situations that have happened in the past. I cannot change the past. We've learned from the past, and you have our commitment that we are going to be maintaining our water quality and responding as quickly as possible in the future for any situations that require our attention. And our interests are also to protect and serve the customers here in the City of Laredo and in Texas.
Thank you very much. Yeah, thank you. Was there somebody else who wanted to speak, or did you have additional comments?
I don't know if you can hear me. This is City Attorney Benavides.
You're coming in loud and clear. Thank you, sir. Go ahead. And suddenly you're not.
Go ahead,
Yes, sir.
Go ahead, sir.
I did want to say, I think the last time the Assistant City Attorney was here, he had spoken on the city's behalf, and I think the commission may have had a question as to a reason for delay. There's a 7-day delay on the boil water notice, and the commission would like, I can address that point at this time.
Please do.
Okay, thank you very much. Yes, honorable members of this commission, I'd like to say that the delay in issuance of the boil water notice was not due to disregard of the TCEQ's direction, but rather it was a utilities department understanding based on its interpretation of TCEQ's rules that it would have 24 hours to address the low TCL samples allegedly identified by TCEQ conducting the flushing means. And so to that end, when they had a boil water notice based on what they interpreted as low chlorine levels, at what the reason for the boil water notice, they began to flush out the lines in the area and take measures to bring the level back up to compliance at 0.5 level or higher. This occurred, but then the levels slipped when TCEQ tested. They were in communication with TCEQ, so then they were under the impression that when this happened, that they could have another 24 hours to go ahead and bring the levels back up to 0.05. They were in constant communication, but I think this was a repeated, repeated behavior leading up to the time when they finally gave the boil water notice. But at no time did the city intend to disregard that notice. They were simply trying to come into compliance within the 24 hours, misinterpreting, I guess, the final or the bases that the commission had given the boil water notice in. But it was not intentional, members of the commission.
All right, thank you, sir. I think I understand what you're describing to us. Colleagues, any questions for the city at this point?
I appreciate the representatives of the city of Laredo coming today, and I think the question that I most wanted to try to address at our last commission meeting, which I think is appropriate here, is the some of the discussion in the news articles around the event that at least one article was submitted as some supplemental evidence from a commenter from the public, and so it raised the issue here of some level of discussion in the city's determination of when and whether to send the boil water notice. I think the appearance or the implication was, here's the cost of the penalty. Here's what would be paid in lieu of putting up a public water notice. I think that falls directly into a sensitive area that I've seen since I've come into this role, in terms of members of the public expressing concern about private companies or industry or even public entities operating under our environmental laws making dollar and cent decisions over whether to put protective measures in or whether, and I think that it just speaks directly to a very uncomfortable area that by and large, I think we and all the operators in this space are working working earnestly to impose every protection for the public's sake, regardless of cost, or regardless of those sorts of side factors. I just want I'll simply say that I appreciate y'all coming back and speaking before us, and I hope that you take sincerely our concerns, or my concern at least, of the potential for the appearance to the public of cities, any entities that are regulated under our laws, making decisions whether to notify the public of possible harms or risk, or whether they can bear that cost. I think that sort of a consideration really does undermine the public's confidence in our agency and in all the entities that we regulate and allow to operate in the state. So I will merely pass on the urging to you and your colleagues to take seriously that obligation and to try to adopt a mindset of thinking of those sorts of utility factors secondarily after public health considerations.
Thank you, Commissioner Janeka. I'm going to ask somebody from staff, from either our drinking water program or Office of Compliance and Enforcement, to share their views in reaction to the city's presentation. But I'll give you a moment to warm up on that. And while you're getting ready for that presentation, we do have Kristen Adams signed in to speak on this item. And Ms. Adams, I'd like to give you your time now. You can go ahead and speak when you're ready.
Thank you, Mr. Chairman, and good morning to you and the other commissioners. My name is Kristen Adams, and I am an attorney with Texas Rio Grande Legal Aid, and here on behalf of our client, Acción de Gente Unida para Agua Segura, or Aguas. Aguas was encouraged by the chairman's and commissioners' grave concerns at the last meeting with the city's delay in issuing the boil water notice, but those concerns should not be left blowing in the wind. Aguas firmly believes that the facts in this case qualify the violations at issue for a findings order because, one, the city has shown that there is no that there is an absence of management practices designed to ensure compliance. And 2, the city has shown blatant indifference to its legal duties in the management of its public water system. This is demonstrated by examining the city's pattern and practice of violating various reporting requirements. For example, the issuance of a boil water notice in this case was not discretionary, yet the city waited 7 days to issue the notice, even when TCEQ unequivocally told the city that it was legally required to do so based on testing conducted by TCEQ, not alleged deficiencies. To this day, the city continues to deny any wrongdoing for failing to timely notify consumers of potential issues with the water supply. Approving the proposed agreed order before you today will only embolden the city in this false narrative rather than protect consumers' health and deter future violations. Further, TCEQ's investigation of these violations, conducted between September and October 2019, noted that numerous entries on the city's operator logs indicated chlorine levels in tanks and distribution sites lower than the minimum required levels, and that nitrification had potentially been occurring since at least May 2019. This means that for at least 4 months, the city failed to self-report these serious water quality issues to both TCEQ and its consumers. Despite its legal duty to report, the city has shown a complete lack of interest, concern, or sympathy to not only its consumers, but also the state agency. If the city elected to establish management practices designed to ensure compliance, then TCEQ and consumers would have been notified of these issues at the time they occurred, as required by law. What's worse, the city has a history of failing to keep chlorine levels above the minimum required level. The city was cited for failing to maintain proper chlorine levels in a notice of violation letter dated August 4th, 2015, and a separate enforcement action resulting in an agreed order dated March 27, 2018. However, given the city's pattern and practice of failing to report, who knows how many operator logs note inadequate chlorine levels. This is alarming to Aguas and should be viewed suspiciously and critically by this commission. The city is no stranger to TCEQ enforcement actions, yet to Aguas' knowledge, TCEQ has never imposed a findings order against the city. Perhaps this is one of the reasons why the city does not take this agency seriously. For far too long, the city's lack of compliance-driven management practices and indifference to its legal duties has repeatedly put consumers of the city's public water system at risk. That is why we ask that you withhold consent on the 1660 order and instead impose a findings order. Thank you.
Thank you, Ms. Adams. I appreciate that. Colleagues, any questions for Ms. Adams?
No, thank you.
Is there someone from the Drinking Water Program or the Office of Compliance and Enforcement who's in a position to share their perspectives on this item, including the city's explanation of their view of it?
Yes, Chairman. This is Brian Sinclair of the Enforcement Division representing the Executive Director. What was mentioned earlier by the city's staff is accurate. There was communication between the agency and the city that went on for the several days that this incident was going on. There was consistent communication from the agency to the city that the city needed to issue a boil water notice, and the city did not do that for several days, despite all of that communication from the agency. The penalty was enhanced. We did a culpability enhancement to the penalty based on that because they had not heeded the instruction from the agency to do that. They were aware that was our position. We also have Jaime Garza available with us from he's the regional director of the Harlingen and Laredo regional offices, and he's available if there are further questions about that.
Thank you, Mr. Sinclair. Good morning, Mr. Garza. Yes, I would just ask you to add anything to this story you'd like to add.
Good morning, Chairman. Thank you for that. I appreciate Mr. Benavides and Mr. Garcia providing those comments, and I can confirm that we did work with the city as soon as we found out that there were low chlorine residuals. It is routine and typical for us to work with any regulated entity that provides water to citizens 24 hours to see if they can correct that issue. Many times it's corrected by either flushing, or they might make some improvements to the system, and you'll have chlorine residual come back up and no need to issue a boil water notice. That was not the case in this instance. We did allow 24 hours. After the 24 hours with excessive flushing, it was clear that the chlorine residuals were not coming up. So after those 24 hours, we communicated the requirement to issue a boil water notice to the city. It was communicated by the investigator, by the section manager, and myself to varying levels of management. And we continued to communicate this requirement while at the same time providing assistance to raise the residual. So beyond requiring the city to issue a boil water notice, the Laredo region was also assisting during this time in conducting their investigation. The TCEQ provided emergency delivery of bottled water, 2 truckloads, 83,000 bottles, provided technical assistance to the city in converting from chloramines to chlorine. We conducted also extensive verification sampling and shared our results. We supplemented the city's efforts in loaning the city monitoring equipment. Of course, we joined the city in their efforts to communicate with the public through press conferences, and even appeared before their council meeting and answered their questions. So that's just kind of a very general summary of some history with the case. To provide an update on what's going on here recently, after the boil water notice was issued and was lifted, the Laredo region conducted unannounced reconnaissance investigations to sample for chlorine. And we did this on at least a quarterly basis, and we did this in an unannounced manner. There were a couple of instances where staff documented low residuals. The city was quick to respond and took action to raise the chlorine residuals. There was one instance in June of 2020 that resulted in a boil water notice, that resulted in a requirement to issue a boil water notice because, again, chlorine residuals could not be raised. And the city issued the boil water notice in a timely manner and as required by rules. Here recently, in fact, last month, there was a boil water notice that was required due to a line break, and the city issued a boil water notice as required by rules as well.
Thank you, Mr. Garza. So it sounds like there have been instances where there's been cause to issue more boil water notices, and at least after the event at issue in this enforcement matter, the city has acted appropriately, promptly, and issued all necessary boil water notices. Is that fair?
That is correct. That is fair. In fact, on the most recent one, the from the line break last month, that was issued without the TCEQ's prompting.
Thank you, Mr. Garza. Colleagues, I'm struggling with this one a little bit. What Ms. Adams has described, doesn't ring incorrect to me. It rings a little true. I'm not sure that I heard contrition or an acknowledgement that the city erred in this case. Now their conduct after this event seems to have been appropriate and in line with what we expect, but I heard I heard the city explain its position that it wanted to argue a legal interpretation in the middle of an event where the quality of the water was questionable. And so I don't know if we should move forward with this agreed order or send it back to OCE for a different result. I don't know how you're feeling about it, but let me just throw it out there.
I think I'm comfortable moving forward with adopting of how it's been proposed. And I just go back to what I saw on the record, which was that the ED had noted that they did, slap the 25% enhancement on there, and they didn't offer the 20% deferral. And so, I always struggle with what does what does a remand get us? I'm not saying it wouldn't change the outcome, but these penalties are set low for a reason, right? Because it's you don't want cities, who's usually the water provider, or the drinking water provider, to have to spend an arm and a leg, because you want that money to be applied to the system to do a fix, or basically just not be passed on to a ratepayer, which is the citizens. So I'm always very torn on that penalty is not enough, but I also understand the reasons why it's not enough, because ultimately we just want clean drinking water for those folks, and at the end of the day, they're the ones that would have to pay for a misstep. So I'll stop there and just say I'm glad the discussion today happened. I do appreciate everyone's participation, the city and the folks that commented on the enforcement matter. I thought they were good comments, but I where I am right now is that I'd be fine adopting what's been proposed and without a remand.
Thank you, Commissioner. Thank you, Commissioner Lindley. Commissioner Janeka, what do you think?
I have one last thread, if you might indulge me to circle back and ask a question of ED staff.
Please do.
And I'm not sure if it's Mr. Sinclair or who from the Office of Compliance Enforcement or other programs might be available or best posture to speak to this. But what would you be able to respond to the suggestion from Ms. Adams about the appropriateness of a findings order as opposed to an agreed order? What impediments might exist in our analysis or our agency's processes that would have prohibited or limited our ability to reach a findings order for this item?
Commissioner, this is Brian Sinclair again. We didn't view the violations as meeting the findings criteria because there wasn't a complete lack of management practices designed to ensure compliance. There was certainly a disagreement from the city's point of view about what the proper way to respond to it and whether or not a boil water notice was necessary, because they were reaching the 0.5 at various points, but they weren't able to sustain it. And as Jaime Garza has already said, it was obvious to the agency at least that they weren't hitting it. And I think the city's position was that, or it seemed to be that the 24-hour clock started over again somehow when they reached 0.5 at some point in their testing. But from our perspective, that if we did a findings order for a lack of management practices, that would be, I'd say, inconsistent with how we've dealt with it in other places. We tend to look at the management practices findings criteria, or the lack of management practices findings criteria, as being something of a bigger magnitude than exists here in this particular case.
Thank you, Mr. Sinclair. I appreciate that.
I'm still staring at you, Commissioner Janeka.
Yeah,
you
I
need
appreciate
to solve
that.
This for us.
No. I think you landed exactly on the piece that's most troubling me, Chairman, and that is the city's decision to reiterate and I would say direct efforts behind making a legal argument to fend off our requirement to post a boil water notice, rather than directing those efforts at addressing the root cause and getting to the underlying issue. I'm not sure that I'm hearing very meaningful outcomes from the refer back to the executive director for further consideration, but I will defer to you in terms of where you see a path forward from that direction.
Yeah, let me dive in and see if I can. Well, I'll just share some more thoughts in no particular order. I was not satisfied with where we were at the last agenda, and I'm still not satisfied. I don't know whether there's actually any true ambiguity in the Federal Safe Drinking Water Act or our rules as to whether or not you get to restart that 24-hour clock every time, every time you come back into appropriate levels. That doesn't seem like the right result to me. I doubt the authorities are ambiguous. But even if they were, I think the whole philosophy behind the Safe Drinking Water Act is you err on the side of caution, and you interpret the rules based on the side of caution. That's something that in my mind ought to be done in the moment. You can fight about the legal merits later. Let's be err on the side of caution, give our citizens notice. So being that I'm still not satisfied, I think the path forward is continue this item again so I can educate myself personally about what the statute says, look for any ambiguity, and explore whether a findings order is appropriate in this case. Because, I think I'm hearing some disregard for the spirit of the authorities, certainly perhaps even for the letter of the legal requirements, and that that may or may not get us there on a findings order. More important than the form of the order to me, though, and the amount of the penalty, because our statutory authority to impose penalties on drinking water systems is so limited for the reasons Commissioner Lindley outlined. So more important than the actual form or penalty amount in the order is just to have an understanding with all of our, and I think I said this at the top, with all of our regulated drinking water systems, that we really err on the side of the caution in terms of how we manage these systems, the notice that we provide the public, and so forth. So I think where I am is, let's continue this thing again. I'll do some more homework, and we can have at it at the next agenda. Not married to that idea, but would be happy to hear your thoughts, colleagues, on that idea.
I will express some agreement in terms of I'm less dissatisfied today than I was the last time the city came before us on this matter, but I'm with you on outstanding concerns, and in particular to this discrepancy in the interpretation of whether there's a resetting 24-hour clock. How does 24 hours get us to a full week of after the initial signals of a need, of an apparent need for a boil water notice? So I think absent some different tone and commitments from the city that goes beyond what I think I've heard today, I'm certainly comfortable continuing to further consider it. So,
thank you, Commissioner Janeka. All right. Well, I think we've landed at a place that we can all live with old business too. But before we land squarely there, I just wanted to give Public Interest Council an opportunity to share any thoughts that they may have, if they've developed any thoughts on old business item 2. Mr. McWhorter, have you looked at this item? Have you developed any opinions on it?
Yes, Chairman, I have looked at it. I support your idea of continuing it. As to whether there should be a findings order or moving forward with the order in its current form, I've been on the fence about that. I understand the executive director's position about how they explained that the order was developed in accordance with the penalty policy, and that the amount of penalty and the type of the order is based on the specific incidents in the investigation report, and it's consistent with the penalty policy. But the comments that were made both today by Ms. Adams and by the gentleman who commented at agenda last week, I think have raised some valid points about whether the respondent has shown sufficient regard for regulatory compliance and protection of public water supply. And I know we're focused on boil water notices and whether that specific rule requiring them has been complied with, but I'm also a little concerned about why there seems to be a need for so many boil water notices. And looking over some of the background of this situation, I mean, the one incidents, I think that was referred to by someone today about that occurred in June of 2020. Someone who's on the line, may be able to correct me about this, but my understanding of that situation is that that was an ongoing situation that covered approximately 4 months of time when, there was a substantial issue with the quality of the drinking water, I believe because of chlorine residuals. So, my takeaway from this, as you've all said, the main concern is supplying the folks of South Laredo and all of Laredo with safe drinking water. And whatever the order that may come out of this that results, I know currently the proposed order has a provision that requires within 45 days of issuance that there be certification submitted documenting that the respondent has management and housekeeping practices in place to ensure good drinking water conditions at its systems and facilities and equipment. So, my hope would be, as I'm sure shared by everyone, that be taken very seriously and monitored very closely. And if there are any questions or future violations relating to not just boil water notices, but whatever management practices may be affecting the quality of drinking water, that enforcement be escalated to try to get a better situation there than seems to exist currently. So those are my random thoughts. So thanks for letting me share.
Thank you, Mr. McWhorter. I appreciate that. So in a nutshell, greater scrutiny may be in order. I think that's a matter for another day, but germane to this conversation. So I appreciate the comments. Well, colleagues, if you'll indulge me and let me continue this another week to do some more homework, I would appreciate that. And I'm seeing nodding.
I'm fine with that.
So I think we may have resolved old business 2 for the time being. I think we're going to take this all up in one motion when we get to it. So I do want to close out our work on the rest of the docket. Ms. Smith, was there anyone signed in to speak on any of the other enforcement items?
On item 29, we had someone signed in to speak, available for questions only, and they will be noted for the record.
Thank you. And that takes us, Mr. McWhorter, back to you. If you have for your comments on the rest of the enforcement docket.
My office reviewed these items, and we support the issuance of the orders as proposed by the executive director.
Thank you, Mr. McWhorter. I agree, colleagues. Any questions or comments on the rest of the docket?
I had a question on item 5 on the enforcement docket, and that might be best directed to executive director staff. The question was merely, did the documents and records that were requested of the respondent at the time of the first nuisance odor violation, were those ever delivered? I took a closer look at the investigation report, and perhaps I missed it when I went back late last night, but I would love to hear from ED staff to speak to that directly in terms of the respondent for item 5. How are we doing in terms of their responsiveness to date?
Well, this is Brian Sinclair again for the executive director. I don't have specific information on the responsiveness of them on providing additional information. My understanding is that there's been one complaint that's occurred since then since the investigations that resulted in this particular enforcement action. There's been one instance of a complaint for dust emissions, and that's currently still under investigation by the region. But outside of that, I don't have additional information.
Okay. I appreciate that, Mr. Sinclair, and I was hoping to see if there might be anyone available for a quick CREET of Dallas, Alvarado, for the respondent to step in, and I don't think that it appears we have anybody here today for them. Taking a closer look at that investigation report, and I'm very sensitive, I think, to wherever matters come before us that originated in complaints, and so that's just putting my cards out. That's where I've tried to allocate a little more of my limited attentions to better educate myself about the enforcement items that come before our agency. I wasn't encouraged to look closer at the investigation reports for this item and to see observances of staff, our inspectors who are at the site pointing out that appears to be a violation to us, and staff noted that there weren't any further actions taken by the applicant at that point to address it or to try to modify operations, which I think further would have violated the special conditions of that permit under which the entity is operating under. So I would really love to try to have a bit of a discussion with this respondent, if possible. So if we might continue item 5, that would help address many of my concerns in terms of what appears to be a bit of a longer running challenge here for this facility, where we've seen some repeat nuisance odor violations or failure to maintain watering practices, things of that nature. So if y'all don't have any objections, I'd like to continue that one.
Yeah, on new business 5, I don't have an opinion and I don't have an objection to that. Commissioner Lindley?
I'm fine continuing. I'm like you, Chairman, so that's fine with me.
All right. Tell you what, I'm going to lay out a motion, and then we can invite any additional comments or a second to it. I move that we continue old business item 2 and new business item 5 until the next agenda, and that we adopt new business items 6 through 29 as recommended today by the executive director. Colleagues, additional comments?
I was going to second.
I heard a
sorry.
second. Any additional comments? All right. The motion has been made and seconded. All those in favor say aye.
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 The motion carries.
Item 30 is the consideration of a petition for rulemaking filed by Chambers County Municipal Utility District Number 3 to amend 30 Texas Administrative Code, Section 293.59, concerning the maximum allowable combined projected tax rate and combined no-growth tax rate for water districts. Chambers County Municipal Utility District Number 3, the petitioner, is represented by David J. Klein and is the moving party and should present the matter, followed by other interested persons. Currently, no one is signed in. The ED, and then OPIC. The Office of General Counsel recommends limiting the speakers to 5 minutes each for presentations.
Good morning, Mr. Klein. Can you hear us?
Yes, I can. Can you hear me?
Loud and clear. Go ahead, sir.
Terrific. Okay. Well, good morning, Chairman Neerman and Commissioners Lindley and Janeka. Again, my name is David Klein. I'm an attorney at Lloyd Gosling here in Austin. And I'm representing Chambers County, MUD number 3, with this petition. I know I've got 5 minutes here. I certainly don't intend to take up all 5 minutes. But essentially, this efficiently sized rulemaking proposal seeks to amend Title 30, Section 293.59 of your rules, specifically subsections K3A, K4A, and K11C, Romanet 1. We're seeking to have the rules modified to increase the combined projected tax rate and combined no-growth tax rate for Chambers County. You have 3 distinct groups in your rules in those 3 subsections for the maximum allowable tax rates. One is centric to the Houston Metroplex. Another one is centric to a lot of other cities in the state, bigger cities in the state. And then you have a catch-all. And at this time, Chambers County is not in the Houston-centric subsection, and we would like to get Chambers County included in that subsection. It's our understanding that these 3 groups were created back in 1989, and there really hasn't been any modifications to this rule since. And we think adding Chambers County to the list of Houston Metroplex counties would reflect the current state of the Houston area as things are today, and it's appropriate for them to be included. And again, those Houston-centric counties are Harris, Galveston, Montgomery, Fort Bend, Waller, and Brazoria. I don't want to go through the petition and all the details and graphs and charts that we provided, but in short, the population growth that we're seeing and The home growth in that area supports and justifies including Chambers County with these other Houston-centric counties. The growth rate is not only today in Chambers County where the other counties were back in 1989, but it's even exceeding some of those counties today and at that time. And so we think that this, while certainly wasn't intentional, could, I guess I have to put it in terms of an injury or inequality, inequity. I think bringing them into the fold with the other Houston counties definitely rectifies that and puts them all on level ground. We think that certainly the ability for MUDs in the Chambers County area have the ability to issue more, have the opportunity and discretion to issue more money in bonds, to pay for improvements for the tremendous growth that we're seeing and people coming to our state and specifically into Chambers County. It'll positively affect the state's economy. And so we appreciate the executive director's initial review here of our rulemaking and your willingness to put this on this agenda. And we ask that you authorize this for this rulemaking for publication into the Texas Register. Thank you. I'm certainly available to answer any questions you may have.
Thank you, Mr. Klein. I think your petition is pretty clear what you're after, and I don't have any questions for you. Commissioner Lindley?
No questions, thank you.
Commissioner Janeka?
Not at this time.
All right, we'll hear next from the one other interested person who just signed in. William McCabe, are you with us? And Mr. McCabe, you might check your mic, make sure you're not muted. And we still can't hear you, but let's just pause for a moment and give you an opportunity to get that sorted out if we can. We made a mistake. Mr. McCabe has signed in to speak on the next item, so we don't have any interested persons on item 30 beyond the petitioner. So we'll hear next from the executive director.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Chris Holm of the Water Supply Division. With me today is Hollis Henley from the Environmental Law Division. On April 16, 2021, Lloyd Gosling, Rochelle, and Townsend PC, on behalf of the Chambers County Municipal Utility District Number 3, filed a petition for rulemaking. The petitioner requested that the Commission amend 30 Texas Administrative Code, Section 293-59, K3A, 4A, and 11CI by increasing the maximum allowable combined projected tax rate from $1 to $1.50 and the combined no growth rate from $2 to $2.50 for the first and subsequent bond issues by a water district subject to the jurisdiction of the Commission that is located in Chambers County, Texas. The Executive Director recommends the initiation of rulemaking with Chambers County District stakeholder involvement. Through the stakeholder process, the Executive Director will further evaluate the merits of the rulemaking proposal to ensure the rule amendment provides economically feasible maximum allowable tax rates that are sufficient to support debt service payments for existing and proposed bonded indebtedness in Chambers County. Without further evaluation, the Executive Director cannot provide an informed opinion on the specific tax rate the petitioner is proposing. Maximum tax rates on the combined projected debt service tax rates and combined no-growth debt service tax rates are determined according to the feasibility history of districts in different areas of the state as identified by county. Therefore, the Executive Director does agree that the maximum allowable combined projected tax rate and combined no-growth tax rate for Chambers County should be re-examined according to more recent feasibility history. Thank you, and we are available to answer any questions.
Thank you. I have none. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeka?
None, thanks.
Mr. McWhorter, what are your thoughts?
OPIC supports granting the petition to initiate rulemaking so that further stakeholder input can be obtained and evaluated as recommended by the Executive Director.
Thank you, Mr. McWhorter. I agree with you and the Executive Director. I think we should explore the merits of this petition with the stakeholders through a rulemaking process. I'm going to caution, as I try to do always, certainly do it routinely, caution that this does not mean that we are going to adopt any particular rule language. It just means that we're going to take a serious look at it, and that we may, if appropriate, adopt a rule in response. Colleagues, any objections to moving forward with this?
None.
I will make the motion that we direct the executive director to initiate rulemaking to examine the issues raised in the petition for rulemaking filed by Chambers County Municipal Utility District Number 3 concerning amendments to 30 Texas Administrative Code Section 293.59.
I second.
The motion has been made and seconded. Mr. Klein, I want to thank you for bringing this petition to us. All those in favor say aye.
Aye.
The motion carries.
Item 31 is the consideration of the publication of and hearing on the proposed amendments to 30 Texas Administrative Code Chapter 311, Watershed Protection, related to best management practices for sand mining facilities in the San Jacinto River watershed. The executive director's staff is here to present the item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Entrance Counsel. On behalf of the Executive Director, I am Michaela Coleman with the Water Quality Division. With me today are Rebecca Villalba and Erica Crespo with the Water Quality Division and Michael Parr with the Environmental Law Division. Based on petitions the Commission received from the Lake Houston Area Grassroots Flood Prevention Initiative and the Texas Aggregates and Concrete Association in June of 2020, the proposed rulemaking adds new sections in the Watershed Protection Rules, Chapter 311 of Title 30 of the Texas Administrative Code, and establishes requirements for sand mining facilities in the San Jacinto River watershed. The proposed new sections 311.101, 311.102, and 311.103 would include the following. A. Define the San Jacinto River watershed, which will identify the scope of the proposed watershed protection rules. B. Require the executive director to develop a guidance document of best management practices for sand mining facilities in the San Jacinto River watershed. C. Require sand mining facilities in this area to develop and implement BMPs from the guidance document of BMPs developed by the executive director. D. Require sand mining facilities in the San Jacinto River watershed prior to terminating operations at the site or portions of the site to submit to the executive director a final stabilization report signed and certified by a Texas licensed professional engineer or geoscientist. The report must include the elements described in the BMP's guidance document. And E, require sand mining facilities to implement and complete the final stabilization report prior to terminating authorizations as required by 30 Texas Administrative Code, Chapters 205 and 305. Staff respectfully requests approval for the publication of and hearing on the proposed new sections of Chapter 311, Watershed Protection Rules. Staff also requests permission to make non-substantive revisions to comply with Texas Register requirements. Thank you. We are available to answer any questions.
Thank you, Ms. Coleman. I appreciate it. I don't have any questions. Commissioner Lindley, any questions?
No questions. Thank you.
Commissioner Janeka, any questions for Ms. Coleman?
No, thanks.
Seeing none. We'll hear next from interested person signed in, Mr. Leftwich. I think you're up first. Good morning, sir.
Good morning, commissioners and staff, and I just would like to thank the staff for their work in regards to this rulemaking. TACA has worked diligently over the last 2 years. It really started after the 2019 legislative session, 86 legislative session, working with local stakeholders and the Lake Houston Grassroots Flood Prevention Initiative and State Representative Huberty's office and Senator Creighton's office in coming up with rulemaking that would work for everybody. And I think it's been a long process over the last 2 years, but I think it's been a worthwhile process. And in the end, we're pleased with this outcome of this rulemaking and the process that TCEQ has put us through to get everybody's input and to put something in place for this area that will work with industry and the local stakeholders of this area.
Well, thank you, Mr. Leftwich. I appreciate that. And we'll hear next from William McCabe. And good morning, Mr. McCabe. I'll ask you to let us know if you're here just representing yourself or if you're affiliated with any particular group, and do that, and go ahead and share your thoughts.
Thank you, Mr. Chairman and Commission members. Yeah, my name is Bill McCabe, and I represent the Lake Houston Area Grassroots Flood Prevention Initiative, one of the original petitioners in this proposed rulemaking. And I would just like to reiterate what Mr. Leftwich outlined, that we've been working on this for a couple of years. TACA and my group and various other parties have been involved in this, and as well as TCEQ. TCEQ has done a fine job of putting together a listing of the rules and the initial rulemaking. We encourage their continued participation. We will certainly continue to participate. Right now, we're waiting on the guidance documents, which will give us some more insight and allow us to make some comments later in the process. But once again, I'd like to thank TCEQ for all their help, and likewise TACA for their input and assistance here. Once again, thank you very much.
Well, thank you, Mr. McCabe. I wanted to thank Mr. Leftwich, too. I feel like you gentlemen are doing real service to your communities and to the state. Colleagues, any questions for Mr. McCabe or Mr. Leftwich?
No, thank you both.
Seeing none. Ms. Smith, we don't have anyone else signed in on this?
No, we don't.
Mr. McWhirter, what are your thoughts?
OPIC recommends approval for publication of and hearing on proposed new subchapter J of the Commission's Chapter 311 rules as presented by the Executive Director.
Thank you. I agree. We've had really excellent stakeholder participation in this process. I do think we're ready to put this proposed rule out for comment, and I think that's the extent of my thoughts on it. Colleagues, anything else, or do we have a motion?
I can make a motion. I would move that we approve the publication of and hearing on the proposed amendments to 30 Texas Administrative Code, Chapter 311, as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries.
Item number 32 is the adoption of amendments to and repeal of certain sections in 30 Texas Administrative Code, Chapter 116, control of air pollution by permits for new construction or modification, and the corresponding revisions to the state implementation plan. The Executive Director's staff is here to present.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Michael Wilhoit with the Air Permits Division. With me is Terry Salem of the Environmental Law Division. This adopted rulemaking amends Chapter 116, Control of Air Pollution by Permits for new construction or modification, to align rules relating to the applicability of prevention of significant deterioration and non-attainment new source review requirements with project emissions accounting rules recently adopted by the United States Environmental Protection Agency, or EPA, and to encourage emission decreases that may not otherwise occur or would be delayed. The adopted rulemaking will also repeal obsolete rules associated with the permitting of grandfathered facilities. Selected revisions to Chapter 116 will be submitted to the EPA as a revision to the state implementation plan. The proposed rules were published in the January 1, 2021 issue of the Texas Register. A public hearing was offered on January 26, 2021, and the public comment period closed on February 3, 2021. The rule team did receive public comment, which was generally supportive of the rules as proposed. The rule team did not make any changes to the rules for adoption. In conclusion, staff respectfully recommends adoption of these amendments and repeals to Chapter 116. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. We are available to answer any questions.
Thank you, Mr. Wilhoit. I have none. Commissioner Lindley, any questions?
No questions.
Commissioner Janeka?
None.
Ms. Smith, has anyone signed in to speak on this item?
No one signed in.
Mr. McWhorter, what do you think?
OPIC recommends adoption of this rulemaking for the Commission's Chapter 116 rules to delete obsolete provisions and revise other sections of the chapter to comply with federal guidance. We support the proposal as presented by the Executive Director.
Thank you, Mr. McWhorter. I agree, colleagues. This is an easy one. We're removing some obsolete provisions. We're bringing our rules in line with current EPA guidance. All of the commenters expressed support. We haven't changed anything since the proposal, so I think we should go ahead and move forward with adoption.
I will, seeing a head nod, I will move that we approve the adoption of amendments to 30 Texas Administrative Code, Chapter 116, Control of Air Pollution by Permits for New Construction or Modification, the repeal of 30 Texas Administrative Code, Chapter 116, Subchapter H, Permits for Grandfathered Facilities and related sections, and corresponding revision of the State Implementation Plan as recommended by the Executive Director.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries.
Item number 33 is our public comment session. We don't currently have anyone signed in to speak at this time, but we'll pause for a moment and allow the line to be unmuted.
So I think our line is open. If anybody has dialed in to speak on item 33, that's just an open public comment session. You can go ahead now. Hearing none.
Well, that takes us to the end of the items posted for open session. The commission will meet in closed session in room 440. Well, I'm sorry. Would the commission like to meet in building F or in this building?
I don't have an opinion. This building's fine.
Okay, the commission will meet in closed session in room 211S of building E as permitted by the Open Meetings Act, including Texas Government Code sections 551.071 and 551.074, to take up and consider matters pursuant to items numbers 34 through 37 as posted and noticed.
Thank you, Ms. Smith. So either I or our general counsel, Ms. Smith, will come back to gavel us out of the meeting, but we'll be in executive session, and with that, the time is 11:52, and we are in recess. so long I've forgotten. I don't need to gavel us in. I just gavel us out, right? Okay. Yeah, that's what I got. Oops. Yeah. Thank you.
The commission met in Building E 211S in closed session from 11:56 a.m. to 12:45 p.m. on item numbers 35 through 37 as posted in notice pursuant to Texas Government Code Section 551.074. No action was taken.
The time is 12:47 and we are adjourned.